Welcome to Criminal Law Unfiltered.
Hello, and welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group and a criminal defense attorney based in Los Angeles with over 40 years of experience handling serious criminal cases, including homicide, sex crimes, and high-stakes federal indictments. He's personally defended more than 4,000 clients and is known for fighting back hard when the stakes are the highest. I'm Heidi Mack, and today we're looking at plea deals. Robert will explain how they happen and what you should know before considering one. This episode is Plea Bargains Explained: How Criminal Case Negotiations Work. Thank you, Robert. Thank you so much for joining us again.
Thank you for having me again. How are you?
Good. Enjoyed speaking with you always here. So, Robert, let's get to it here. First, can you explain what a plea deal is and why they are such a common part of a criminal case?
A plea deal, as you say, that means you're going to settle your case. That means you're going to plead guilty or no contest, if you can, to some criminal charge. And that comes after a lot of time, actually, because you've put a lot of time and effort into the case looking at the evidence. And so normally, most cases, you are looking to see if you could try the case, try it, meaning having a jury trial. And you're seeing what is the probability that you can go to trial and win and convince 12 people that your client is innocent or not guilty, let's put it that way. So if you're taking a plea agreement, or in state court, we normally don't say like a plea agreement or a plea. We just say you're gonna, plead no contest to a charge. Normally, it means that the evidence is strong, and it's so strong you're most likely can't overcome it in front of a jury. So a plea, most cases do result in pleas because if the case sucks, if the evidence isn't there, the district attorney will dismiss the case. If the evidence is weaker, but there is a chance that your client could lose, maybe it's better that you take a misdemeanor, or maybe it's better that you take a felony that you could reduce to a misdemeanor, or maybe it's better you take the plea because you're getting no time. You're getting community service. There's a lot of factors that go into whether or not to take any kind of a plea. But the plea that ultimately results from looking at the evidence, it doesn't come about automatically. It comes back because your counsel is fighting back for you and advocating, your position. And that's all based on a review of the evidence, speaking with your client, talking about the evidence. And, you have to go through the evidence with your client. And if you have a picture, let's just say that part of the evidence that you've been provided by the district attorney, or even federally by the U.S. attorney, it shows a hand, and that hand is got your client's name tattooed all over it. And that hand happens to be in the cookie jar. That's going to be problematic as far as how do we explain that. So you got to show that to your client. Hey, your hand's in the cookie jar here. I mean, that's your hand, right? So what are we going to do with this? I mean, what you have an idea? Do we have some sort of a reason why it would be there, or should we send an investigator to speak with the person who owns the cookie jar? How are we going to explain this evidence? We just need to explain it. And so sometimes just, is no explanation for it. So you need to
Mm.
cover yourself and get the best deal you can.
So, with different scenarios, I'm assuming it's different, but is there someone that usually initiates a discussion about the plea deal? Like, is it the prosecutor? Is it defense? Is it the judge?
No, it's a judge. Not really. The only thing a judge does is manage their caseload. They don't normally. I do have a case right now where we may get the judge involved. You only want the judge involved
Mhm.
in a state case when the DA's offer is high. Oh, it's too high for the conduct. So you approach the bench and you speak with the judge and you go, Your Honor, the DA in this case is really out of line. Their offer's out of line, not that they're out of line, but the offer's out of line. So if we were to plead guilty to or no contest to all the counts, would you lower the offer to settle the case? And that's when the judge comes into play. But as far as who initiates what, I don't ever ask for an offer until I'm ready. I have to have all the evidence first. And once you have the evidence, then it's, normally, I don't know, it's kind of a simultaneous thing. Maybe I'll say, well, what are you guys looking for? And they'll ask me, well, what are you looking for? And we'll see if we can figure it out. But I can't say that I initiate this
Mm.
stuff all the time.
Yeah.
Every
Okay.
case is different.
So maybe more for like more serious ones, like more serious felonies or federal cases. How much room does the defense have to negotiate like a plea?
I can only think about, homicides.
Hmm.
And a homicide, you will, well, if you have a homicide, one of the more common reductions of in a homicide case, and a reduction, I mean the type of a charge that you could
Mm.
plead to, is a voluntary manslaughter. And so normally you're not convincing the DA to offer a voluntary manslaughter in a homicide case until really as you're getting closer and closer to trial, because then all the parties know kind of what your evidence is.
Yeah.
So serious cases take a long time to get like a voluntary manslaughter. Maybe you can get an involuntary manslaughter, but I had a homicide recently where they did offer my client a voluntary manslaughter.
Mm.
And it's something the client needs to consider, because if you get convicted of homicide, at least in California, it's a life sentence. It could be
Yeah.
15 to life, it could be 25 to life, and depending on what kind of a homicide it is. I mean, if it's a shooting, then there's a gun enhancements that can be added to the 15 to life or 25 to life. So there's a lot at stake. My client turned down the voluntary manslaughter, and because he authorized me to offer a voluntary manslaughter and a lot less time
Mm.
with the voluntary manslaughter. They said no. The DA said no. We went to trial, and the guy's found not guilty, and he walked out of the courtroom with me.
Wow.
So um,
Wow.
that's just a little plug.
Yeah. Yeah. No. Yeah. Yeah. Hey,
But
I'm out there. But I mean, you were talking about, he turned it down. I mean, there's those chances. Are there like risks, like when your client decides to turn it down?
of course,
Yeah.
there's always a risk. I have a same situation coming up
Mhm.
in a couple more months. I have the same situation. Actually, it's in the same courthouse
Yeah.
where the client wants a trial. He does have a defense, we've put the defense together. I've put this defense together. But if it doesn't go his way, he's might spend the rest of his life in prison. And so, yeah, there's a lot at stake here. And you just, as long as the client knows what's at stake and they still want to go forward, then it's the client's choice. It's not my choice. It's the client's choice. And so, yeah, but obviously you're taking a plea agreement, or you're a plea agreement because you're weighing the potential for a guilty verdict. Because if you do get a guilty verdict, you're going to get more time than you were offered before trial.
Yeah.
And depending on the judge, it could be substantially more time, but so that most cases do resolve because you get a good deal out of it, and it's not worth the chance of even.
It's like gambling with your life. So, yeah.
Well, you are gambling with your life. That's exactly what you're doing. You're gambling with your life. And so it's a high stakes business.
Yeah. Like say if you, do get into things like, plea, deals and things like that, does a person's prior record and like their cooperation with the whole process, does that help approve it or reject it? Things like that?
Prior convictions do play a role in, plea negotiations. In a couple different ways. First of all, in California has what's known as the strike law. So if you have a prior violent or serious felony, that actually doubles the time that you could get. So if you had a theft charge, a grand theft charge, which carries a potential sentence of 16 months, 2 years, or 3 years, having one prior strike makes that 32, 4, or 6. So if the DA comes in and says, look, we'll strike the strike and we'll give your client 2 years, which is midterm, it's something to consider because you're getting 2 years, and that 2 years is half time, which normally equates under the California rules of court, that equates to 1/3 the time. You consider that rather than go to trial and risk like a judge convicting after a jury trial and you get convicted, a judge sentencing you to 6 years, and that 6 years is supposed to be at 80%, but it's normally done at 66%. So there's a big swing. So prior convictions like that are one thing you need to consider. Also, the DA will consider a prior person's record as well. They will say, look, your client was convicted, in, the year 2000, and they got 4 years. So why would I offer you 4 years again? Or why would I offer you 2 years now when 4 years the last time didn't work?
Yeah.
So that argument, I understand their argument. And when I get that argument thrown back at me, I try to at least get them to agree not to increase the time this time, but to give me something where my client's eligible for half time, which would be 1/3 the time under the California rules of court. So there's a lot of little nuances you need to be aware of when you're negotiating something for a client or negotiating time for a client.
So earlier in the episode, you were talking about, the judge rarely gets involved, but say if both sides, prosecution, defense, you agree on a plea agreement, can they come in and reject it?
Yes.
Oh,
The judge definitely has the power to do that, to say, I'm not going to approve this plea agreement. I haven't had that. Well, I've had it maybe once in federal court when there's a certain type of a plea agreement.
Mm.
It's called we call it a C1C plea, which means it binds the court, that the court can either accept the plea or reject the plea. And if the court rejects the plea, you start all over again and get a new plea agreement, because the court's not going to do that. In state court, very rarely have I seen a judge say, I'm not going to take it, but I have seen it before.
Okay.
And but it's rare that a judge is not going to accept the plea agreement.
Mm-hmm.
And the reasons for this is that the criminal justice system is full of different parties covering their ass. And I mean covering their ass. I mean, you give somebody a small sentence and they come back and do something heinous, down the road. Nobody, the judge or the prosecutor, nobody wants to be interviewed by the media when they come back and say, look, you had John Smith or Mary Jones and you gave them a slap on the wrist, and now look what they did.
Yeah.
You are light on crime. So,
Geez.
I mean, that's when it happens. I mean, that's what you think, that politics are not part of this. And by politics, I mean, protecting their job,
Mm-hmm.
prosecutor protecting their job, a judge protecting their job, because, judges are reelected.
Yeah.
Federal judges are not. If you're a federal judge, you're a federal judge for life. So they don't really have that type of a concern. But, state court judges are elected, and so is the DA. So,
Yeah.
Everybody's covering their ass in state court a lot, because they don't, they're supposed to be doing justice. And I'll say normally that happens. But
Yeah.
that's an elusive term, doing justice, because I've seen, and I was just in a trial in another neighboring county here, and I've never really seen a prosecutor want a conviction more. And what I mean is, you should be, when we're in trial, seeking the truth and not a conviction. And you're hiding things from the jury. You're portraying this crime as something that it's not. And it's easy for them to do. They have a lot of power. So that's what the defense attorney's job is to level the playing field. So justice can be an elusive thing when you have a sleaze as your prosecutor.
Man. Well, Robert, thank you for giving us all your knowledge, especially on these, plea agreements and these deals. For those out there listening, thanks for listening to today's episode of Criminal Law Unfiltered. Plea bargains can shape the outcome of a case more than most people realize, and having the right defense strategy makes all the difference. If you or a loved one is facing charges in California, visit robertmhelfend.com to learn how Robert and his team can help. And don't forget to like, subscribe, and leave a review if you found today's episode helpful. And thank you again for joining, Robert. It's been a pleasure as always.
Yeah, thank you for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.